Hello everybody, welcome to today's webinar. So in today's webinar we're going to be exploring reasonable adjustments in practice. So thanks so much for everybody for joining me today. As I'm sure lots of you are aware, and I'm sure I spoke to you on the phone as well, my name's Sophie and I work in the HR team for Code. So a couple of our aims and objectives for today's session. So our aim is we want to increase our understanding of how to implement effective, reasonable adjustments for disabled team members, and we want to help our managers comply with employment legislation. So our first objective that we're going to look at is to discuss an overview of the law relating to a disability as a protected characteristic. So we're going to be looking at the Equality Act. Our second objective is to highlight the risks of failing to implement reasonable adjustments. And we're also going to explore throughout today's session to explore the Code Total HR service and how we provide useful policies and template letters to help practices comply with your legal obligations. So our learning outcomes from today's session. Number one is to avoid potentially costly mistakes that relate to disability discrimination. It's also to improve our understanding of the benefits of providing an inclusive working environment. And thirdly, to understand the legislation that's related to making effective, reasonable adjustments. We're going to achieve those aims and objectives today by exploring a few key topics. So our first topic that we'll be looking at is the current legal requirement for making reasonable adjustments. We'll then look at exploring a definition of disability, and the definition is from the Equality Act we'll be looking at today. We're then going to look at the types of effective adjustments that could be deemed reasonable for a practice. And then towards the end of today's session, we'll explore some common mistakes and mythbusters, as well as looking at some case law on disability discrimination. So now we've covered our objectives and the key topics, we'll make a start on today's session. So our legal obligations. As employers, we are obligated under the Equality Act to provide reasonable adjustments to ensure that our disabled team members aren't at a disadvantage. So the Act really puts the emphasis on the employer to provide reasonable adjustments to ensure that we're promoting a safe, effective and inclusive workplace environment. Now, the equality law recognises that to promote equality for disabled people, we may need to make some adjustments to the structure of our employment. So this could be, for example, removing physical barriers or providing additional support for our team members. And these really encompass your reasonable adjustments. So disability discrimination. This can arise from employers failing to make reasonable adjustments and failing to implement those reasonable adjustments for their disabled team members. And it's actually the most common type of disability discrimination, that failure to recognise the Equality Act and your legal obligations. The legal obligations apply to all throughout the employee life cycle. So it starts from that recruitment and selection procedure, where we would need to be prepared and aware of our legal obligations with regards to making adjustments for candidates who are interested in working for the practice, as well as team members that we have employed. And it doesn't matter if they weren't disabled at the point we employed them. If they have a disability that has occurred throughout the employment, we still have that legal obligation to make adjustments where we can. As well as the recruitment and induction process, is also going to touch on areas of employment such as pay-related criteria, your training and development opportunities, as well as towards the end of the life cycle, where we might be having to look at potentially a redundancy situation or a dismissal. So it's just important to make sure that we are aware of our legal obligations under the Equality Act and that we're applying them at the right time. So now we understand where our obligations come from. Let's have a look at exploring a definition of disability. Now, this definition comes straight from the Equality Act, and the Equality Act defines a disability as a physical or mental impairment that has a substantial and long-term negative effect on your ability to do normal daily activities. Now, you'll notice I've highlighted a few key terms within that definition, and I just thought it would be useful to explore them a little bit further today. So the first one I've highlighted for you is substantial. Now, the Equality Act defines substantial as an adverse negative effect, and it's something that's more than minor or trivial. The next key phrase we've got is long-term. So again, the Act defines long-term as something that is either likely to last 12 months, has already lasted 12 months, or may potentially last for the rest of that employee's life. So that's your long-term definition. And then the last key phrase I've got highlighted is the normal daily activities. Now, these are, the Act actually purposely doesn't define these for us because it recognises that it's going to be different for every individual. But what we would suggest regarding them as is things that people need to do every day as part of their life. So that could be getting some shopping, could be cleaning, tidying the house, communicating with each other, and the ability to move around and to get onto sort of public transport, for example. So it's having that ability for moving around and the mobility. So that's really the definition for you. You'll probably recognise that the definition is quite broad because it's going to cover quite a lot of conditions and illnesses will be covered under this definition. So let's have a look at and explore some of the different conditions that could potentially be covered. So there are a few illnesses that are actually automatically covered from point of diagnosis. So these conditions aren't subject to the criteria in that definition. And these are cancer, HIV and MS, as well as if your team member is registered as blind or partially sighted, again, that would be automatically covered. So they aren't subject to the criteria within that definition. The next few conditions that we're going to explore will be subject to that criteria. So it is about having that substantial sort of long-term negative effect on their ability to do those daily activities. So the first condition is mobility difficulty, and mobility difficulties can be triggered by various different types of conditions and illnesses. So, for example, arthritis, it could be a loss of a limb. Those types of conditions will be covered potentially as a disability under the Equality Act. I also wanted to highlight the importance of the non-visible conditions as well. So there are a number of illnesses that you won't be able to sort of recognise immediately that person is disabled. Non-visible conditions could include heart problems, potentially respiratory problems. Those are the types of conditions that may not be automatically visible, but that somebody could be potentially suffering with. Now, your mental health conditions as well, you know, obviously they may come under your non-visible conditions, but I did want to highlight those separately for you. Mental health conditions that could potentially be covered are conditions such as depression, it could be anxiety, eating disorders as well as bipolar disorder. So these are the types of mental health conditions that would potentially be covered as a disability under the Equality Act. But again, they are subject to that criteria, that definition. And then also progressive conditions. So there are some conditions that your team members may have where they may increase in severity over time. So these conditions could include some types of dementia and also lupus. So if you have team members that are suffering with any of the conditions we've mentioned, you may well need to start having conversations with them to ensure that they aren't at a disadvantage in the workplace and explore any reasonable adjustments that could be made for them. So now we understand, what our legal obligations are. We've had a look at what a disability, how do we define a disability and what conditions could be covered. How do we know when it's reasonable? How do we know when we should, consider some reasonable adjustments? So the first bullet point I've got for you is if your team member has come to you and declared that they have a disability. So this could have been throughout the recruitment process. They may have declared that at the interview stage. It could be that they declared it on a medical questionnaire that they filled out for you, or it could have been throughout the employment with you. They may have approached you to let you know of something. So if that team member has come to you and disclosed that to you, then it is definitely worth having a conversation with them to understand a bit more about their condition, if they are at a disadvantage, and what we could do as employers to make some reasonable adjustments to remove that barrier or to remove that disadvantage for them. The next bullet point I've got for you is reasonable awareness. So if we have potentially witnessed within the practice some incidents or some occasions where things may be linked or there may be an underlying disability there. So for example, here we're talking about, it could even be a slip, trip or fall that has been caused by either a blackout or a fit, for example. If you've got that reasonable awareness that you think your team member may have a disability, then it's time to act. Unfortunately, when we're in a tribunal situation, saying that they didn't come to you and declare their disability isn't going to wash, unfortunately, and you would need to be able to act on the fact that you think something may be underlying. So next I've got the requested adjustments. So if your team member has come to you, again, similar to declaring a disability, but this time they might have come to ask for some requested adjustments. Again, this is time to take action. Speak to that team member, understand a bit more about why that adjustment's going to remove that barrier or to remove that disadvantage, because we want to ensure that it's going to be effective for them. I've also got fit notes here for you as well. So some of you, potentially all of you may have seen a fit note before. These come from the GP or consultant. It could be after a period of your team member being signed off as being unfit to work. What we quite often find on fit notes is that they may have been signed as being fit to work with some recommended adjustments. So these could incorporate light duties, or it could be a phased return to work or a reduction in hours or a few more breaks throughout the day. So if we have, if there is those adjustments on that fit note, that's time to take action as well and to consider what the GP or consultant has advised. So once we're aware of a disability and now we know we need to take some action, there are a whole host of support tools out there for you. So it's important to get some advice, to seek some support here. You're not on your own with it. And it's always in your best interest to get these support, because we don't want to end up making adjustments that are ineffective and therefore pointless for us to do. So the first support tool I would suggest having a look at is a consultant or a GP report. So we can get these by discussing it openly with our team member, asking them for consent to contact their consultant or GP, and asking that consultant or GP for their expert opinion on their condition and on whether or not it's going to impact their work life, and if there is anything that they think you could make as an employer for a reasonable adjustment to remove that barrier or disadvantage. Occupational health are also a really helpful support tool. Occupational health can get a bit more involved than a consultant or a GP can. They can come into the practice. They may shadow that team member for a couple of hours or a day, for example. You can provide them with the job descriptions so they can really get a good understanding of what that team member is doing every day and provide you with some really effective suggestions for some reasonable adjustments. I've also got expert associations on here. So these are associations that are experts in their field. So I've got a logo on the screen now for Mind, the mental health charity. So just by going onto Mind's website, you'll be able to have access to a whole host of employer support documents and guidance. They are completely free to download and access, so I would really recommend having a look and exploring your team member's condition so you can see if there's any support out there. So for example, Mind have documents that you can download as employers to get a bit more of an understanding of the condition, as well as understanding what adjustments might be effective in removing the barriers and disadvantages for those disabled team members. ms.org also have some free downloads for employers, as well as Diabetes UK. So there are expert associations out there that you can definitely have a look at and get some more information on the condition, first of all, and then some understanding of what adjustments could be effective for them. The last tool I've got on here for you is HR support. So whether or not that's us on the Code HR helpline or an external provider that you may use. So I think it's really important that you get HR support that can work alongside that expert medical opinion of either the consultant, GP or occupational health. We can help you to implement it, we can help you to document it and ensure that it's reviewed going forward. So a couple of effective adjustments. These are ones that the HR team at Code have seen sort of in practice, have seen them work before. The first one we've got is work patterns or phase returns. Now, phase returns could potentially be a recommendation from a GP, and this could be found on the employee's fit note. So it might be that the employee has been off for a period of time and the GP has suggested a phase return to build up their hours back up to their sort of contractual position. It could be changes to the work pattern, and these could be temporary or permanent changes to help remove the barriers and remove the disadvantage for that team member. So it could potentially be that we're looking at splitting up the lunch hour, and maybe we're having more regular rest periods for that team member. So instead of a block of an hour, we're looking at 3 20-minute sessions where it's going to give them time to recover. It might help them with fatigue that they may have as a side effect of a disability. Adjustments to premises. So this could be that you allow a disabled team member to maybe work on the ground floor instead of on the first or second floor, and this could help with their mobility issues that arise from a disability. It could be that we look at installing ramps for wheelchair users. Those are the sort of adjustments to premises that may be potentially reasonable and definitely effective for ensuring that you're promoting and providing an inclusive workplace environment. Providing additional or modified equipment. So additional or modified equipment to help remove that barrier, remove that disadvantage for that disabled team member. So here we're talking about, it might be ergonomic equipment that team member needs as part of their workstation assessment. It could be that we're modifying the equipment that they use. So it could be that we are maybe extending the handles on things so it's easier for them to get to. It could be that we're providing them with a headset rather than a handset to ease the pain or the stress they may have on their arm, for example. And then we've got modifying policies or procedures. Now, this is one that is very often overlooked, and it's modifying policies or procedures that are either written or unwritten as well. And here we're thinking about things like your sickness absence triggers. So it might be about removing them or reducing them for disabled team members who need to take time off to recover, or time off to help them as part of their disability. Procedural wise, we're thinking about things like making adjustments for, it could be a team member that you have with learning difficulties, allowing them to bring in either a friend or a family member to a formal meeting where they might otherwise have only been able to bring a work colleague or a trade union representative. So it's about making those adjustments. So it's really removing the barriers and removing the disadvantage for that team member. So this is one that will, is probably an age-old question. How do we define reasonable? Now, I've just put a couple of key factors to think about on the screen here, but this list is by no means exhaustive. There are lots of factors that you would need to consider to understand whether or not it's going to be reasonable to implement the adjustment. And it's important also that you balance it. So you need to balance the factors. So the first one I've got on the screen is effectiveness. So it's about understanding whether or not the adjustment that you're going to put into place is actually going to remove that physical barrier or going to remove the disadvantage that that disabled team member is experiencing. Because if it's not going to do that, it might be pointless to do so. When we're thinking about effectiveness, it's also sort of important to remember that it may take more than one adjustment. So it might be a series of reasonable adjustments to get to our end result of removing that disadvantage. The next one I've got is affordability. So just because, so the more, I suppose, the less money it's going to cost you, the more reasonable it is going to be to implement it. But that doesn't take away from the fact that, it's about balancing. It's about a balancing act, really. So it's about thinking about potentially the income of the practice versus the cost of that reasonable adjustment. And what we'll look at in a few slides' time is some statistics and some case law that really will show you how sort of affordable some adjustments are, and the penalties that you may be seeing for not making those reasonable adjustments far outweigh the cost of them. And then I've got practicality as well. So is it going to be practical to implement this adjustment? Also, things to consider is whether or not it's going to put anybody's health and safety at risk within the practice. Obviously, if it's doing that, then it's going to be not reasonable to implement. But as I said, it's going to be a balancing act to look at all the different factors and to understand whether or not it's reasonable for you. What's reasonable for you as well isn't going to be reasonable for the practice down the road. It will be completely dependent on your own circumstances. So on the back of that, then, some common mistakes. And these are mistakes that we have come across as a HR team as well, both on the helpline and in other roles. So the first one, and the real key one, is failing to understand the legal obligation. So this is failing to have that understanding of the Equality Act and that understanding as to what you're obligated to do as employers. The second one is recognising the signs. So as I spoke about towards the beginning of today's session, is having that reasonable awareness. So if it is deemed that you had reasonable awareness and actually you failed to recognise those signs, that is also another common mistake that we're coming up against. I've also got failing to implement. So this is when we understand the reasonable adjustment that needs to be made, but we fail to do so. So it's failing to implement those reasonable adjustments. And we'll have a look in a moment at some case law that they have failed to implement. And failing to get external support. So the real key one here is that we need to get that expert medical advice on what would be effective for that team member. And also the HR support as to understand when would be right to implement and how we document it. So as I mentioned towards the beginning of the session today, we're going to have a look at some Mythbusters. And again, these have been put together by the HR team on the sort of most common themes we get on the helpline. So the first one I've got for you is it will be expensive to hire a disabled person. So that is in fact incorrect. So a lot of reasonable adjustments don't cost anything at all. And I think the average is about £200 per disabled person to make that adjustment. So it's not always going to be expensive. And it's about understanding that quite a lot of adjustments don't cost anything at all. The second myth we have is a job applicant has to tell an employer if they are disabled. Again, this one is false. So a candidate can choose to keep their disability confidential from a potential employer. And then the third one we've got is once an employer has hired a disabled person, they can't dismiss them. Again, this one is false. As long as there is a fair and justified reason for doing so, and you've followed the correct policies, you've followed the correct procedure, so it could be your capability, for example, then you can go down that route with them. But it just needs to be a fair and justified reason, and you're following the right route to get there. So what I thought would be really interesting is to have a look at some stats and case law, because it's all very well me sat here sort of telling you what your obligations are, but I think it's really important to understand, what could happen if we get this wrong. So the government department released its statistics September last year on the basis of the Employment Tribunal Compensation Awards. So disability discrimination awards between 17 and 18, sorry. The maximum award payout for a disability discrimination claim was over £240,000. So it's important to understand and to know that there isn't a cap on disability, any discrimination compensation. There is no cap there. So unlike unfair dismissal, where you've got that higher end limit, for discrimination claims, it's completely uncapped. So yes, the maximum award was just over £240,000. That brings our average award for a disability discrimination claim to almost 31,000. So yeah, they're quite big numbers, and I think it's important to think about these numbers when you're looking at that balancing act of the factors to consider when things are reasonable. So it's thinking about if an adjustment is just a couple of £100, the penalties that you may face for not implementing that could be, astronomical. And then a couple of pieces of recent case law that I thought you'd find quite interesting. The first one being Haxby Group practice. So this is a GP practice who failed to implement some software for one of their team members. It was voice recognition software. They failed to implement this. The team member suffered with arthritis and carpal tunnel syndrome. So she was experiencing a lot of pain in her arms and in her fingers and hands while she was typing. So therefore requested the voice recognition software. The practice failed to implement this, which caused the team member to resign. She ended up taking that practice to an employment tribunal and won, I think it was about £45,000 she won as a compensation for that. And if you just keep in mind that voice recognition software would have cost about £150 to £200 to implement. So, it's about weighing up that balance. The second piece of case law is it was an NHS Foundation Trust. They failed to make reasonable adjustments to their policies and procedures. So it was their absence management procedure. They failed to make an adjustment to recognise that a disabled team member would need additional time off to support their disability. This caused that team member to resign, and that case was taken to a tribunal. The tribunal found in that team member's favour, and that case was settled for an undisclosed figure. So you can only imagine what that might have been settled for. So how do we minimise our risk? So it's not all doom and gloom. There are things we can do to help minimise our risk here. And it's also not just our risk of an employment tribunal, but we're also thinking about our risk of losing team members that have maybe built up lots of knowledge, lots of experience, and are well liked within the practice. So it's how to minimise our risk of an employment tribunal, but also how to retain our disabled team members. So the first step is to take a positive and proactive approach. So it's about having those open, honest conversations with those team members, understand and take an interest in what will help them to remove the barriers and to remove the disadvantage. Secondly, is to provide training and awareness. So we want to ensure that our managers who are maybe on the ground dealing with issues with our team members are aware of the legal obligations. So it's all very well maybe us knowing, but we need to make sure that the people who are, our managers who are dealing with our team day to day also have that awareness. Next, we've got record the adjustments. So this one is also linked to a piece of case law as well that I read recently, where a reasonable adjustment wasn't it wasn't documented on that team member's file. it was a school actually, so the head teacher left, a new head teacher came into place and reversed the adjustment, not realising that it was linked to a disability, which actually caused that team member to resign. And they also won an employment tribunal. So it's about having our audit records there so that if we do have a change in management or a change in structure, somebody else will be able to acknowledge the adjustment and understand the reasons why that's in place. And another way of minimising your risk is to seek that expert support. So get that expert medical advice from occupational health and your GPs and consultants. Have a look out there at some sort of at the guidance that you can get as employers based on the different conditions. And don't forget to seek the expert HR support as well to ensure that you're documenting it in the right way and that you're implementing it. So we do have some key policies and templates on iComply that will be able to support you with this process. So I think the key one to have a look at is the Disability Rights under the Equality Act. That's a really good one to get to grips with your understanding. I would also recommend having a look at the recruitment and selection policy and procedure. In there we have a section about making reasonable adjustments for candidates, so I think it would be really important just to have a look at that one if you can. And we also have documents to help you with getting that consent and then writing to the GP to get that report. You'll probably notice that we don't have as many policies and templates on here as we would for other subjects. That's because every situation is going to be different. Therefore, Total HR members will recognise and understand that we deliver bespoke template letters, bespoke advice on individual situations. So a few actions that I would recommend taking away and having a look at in the next couple of weeks. Firstly, to check your policies and procedures. So ensure that you're not putting disabled team members at a disadvantage by checking and just making sure, having a review of them to ensure they can't be deemed as putting them at a disadvantage. Secondly, I mentioned it before, ensure that your managers understand their legal duties and their legal obligations. So it might be worth asking them to review that module on iComply. Thirdly, check your documentation. So ensure that any reasonable adjustments that are in place in the practice are documented. And then lastly, ensuring that you're seeking expert advice and support. So just to make you aware really, we do have a Total HR and Employment Law service. A few things that are within the service is that you would get access to your own dedicated HR advisor. So it would be somebody on hand who would understand the practice, get to know you and really help with that bespoke support. You would also get access to advanced HR templates, as well as an annual contract review and HR document audit. In addition, you would have access to a web application, and this will really help and support you managing your staff and being able to store documents. If you would like any more information, please do give our professional services team a call and they'll be able to provide you with more information and a bespoke quote. And just to make you aware of some upcoming events that we have, so my colleague Hannah will be presenting a Managing Sickness webinar coming up on the 14th of March, so 2 weeks' time. We also have a Compliance Day coming up in May, so the 3rd of May, and that one will be based in Birmingham. If you would like to book that Compliance Day, please go onto our website. It's codeuk.com/events. There'll be more information on there and you'll be able to book straight from the website. You can also watch all of our previous webinars on the Code UK website. So this was the 8th webinar in our series of 10. So they're all available for you to refer to at any time.